All right, well, good morning. I'm Gary Winnick. I'm the Chief of Enforcement for the Fair Political Practices Commission in California. I'm here today to announce an important development in the dark money case that we've been pursuing since October of 2012. As you recall, the FPPC took swift action prior to that 2012 election to compel the disclosure of the source of an $11 million contribution that was made to a California campaign committee, the Small Business Action Committee, or SBAC, through an Arizona nonprofit that had no history of activity in California. That particular case went all the way to the state Supreme Court before the election and resulted in a settlement the day before the election disclosing that those nonprofits that actually made the contribution. After a thorough investigation in 2013 with the Fair Political Practice Commission and the Attorney General's Office, we reached a civil settlement with the Center to Protect Patients' Rights and the Americans for Responsible Leadership for violations of disclosure laws that resulted in a combined $1 million fine being paid. That was the largest fine ever in California history and also one of the largest ever in the nation. As a result of the prosecution of that violation, state law required that the recipients of those contributions disgorge the funds that they received to the state general fund. Today we're announcing that the two recipients of the contribution, SBAC and the California Future Fund, have signed civil judgments acknowledging that these committees are responsible for the full disgorgement. And additionally, SBAC has made a payment today of $300,000 towards this disgorgement debt, which constitutes for them all of the funds remaining in their campaign account. I should note that even though it is not a fine, it's a disgorgement, the $300,000 represents the second largest amount ever paid to the FPPC, behind only the $1 million fine that was levied in this same case. It represents a very significant cost to SBAC, who throughout our entire investigation of this case were very cooperative and not found to have violated the law. This case was unique in many ways. The sheer size of the contributions in question, some of the largest in California history, made enforcement of this law a challenge. However, the judgment against both committees remain in place for the full remaining amounts. Any future funds raised by these committees will be used to pay down this debt. In conclusion, I just want to say the case, I believe, has accomplished three important things. First, it sends a clear message to those that engage in the political process that we will aggressively defend the public's right to have information about donors, and that the penalties for noncompliance will be steep. This includes enforcing the state's disgorgement law, which for even the recipients means even if they weren't aware of the true source of that contribution, they will still suffer significant consequences. The second thing, this case for the first time put a spotlight on the inner workings of dark money networks and how nonprofits are used across the country to hide contributors' identities. This has led to a national discussion on all of these issues. And then lastly, here in California, it's spurred legislative action to address some of the areas of the law that need to be enhanced to provide the FPPC the tools it needs to enforce the law. Specifically, SB 27 and AB 800, which should be up for a floor vote in the legislature next week, are giving us additional tools and additional ways to get this important disclosure. Today's announcement could also be used to spur a review of disgorgement rules and identify if any of the improvements need to be made in this particular area. As we head into the 2014 elections, we're going to continue to be aggressive in enforcing these laws throughout the election cycle. And with that, I will take any questions.
Is there a timeline they have to pay the rest of the money?
There is no timeline. When we have any sort of debt, seek civil judgments, and then we've kept collections open for years, if not decades.
If AB 800 and SB 27 were in law right now, could this transaction have taken place?
The transaction could take place. The thing that would be different is the first bite rule, which says if you're a nonprofit and you make your first contribution, you are not required to disclose your donors, would not be applicable. So now they would have had to, as a matter of course, disclose their donors up front. It also would have given us very clear tools to go after and compel that disclosure. We had to wind up going to the state Supreme Court. We had that authority, but it wasn't as clear in the language as it needed to be And AB 800 is going to change that and give us that clear authority pre-election to go make sure that that disclosure happens.
Is the total amount 1.3 million then that's been collected?
I don't want to be lawyerly about it, but I will be. The $1 million was a fine. The $300,000, the fine implies that someone violated the act. In fact, it says that someone violated the act. Here, SBAC and CFF did not violate the law, but the law requires that they can't keep a contribution under those circumstances. If I may split that here.
What's the likelihood you'll get any of the rest of the money back?
Any future funds that are raised will be going towards the debt. I'm not going to speculate on whether or not we receive that. It's an open debt, and if it happens, then we will go after that money as well.
Has there been any discussion with them about how much they can pay? I mean, do they just kind of look at you and pull out their pockets and say, I don't have it? Or?
Right after we made the announcement of the $1 million, I engaged with them to make sure that any funds they had in their account remained in their account so we could go through this process. And every dollar that was available to us, we received.
What about the California Future Fund? They're closed. Are you going to get any money from them?
Again, they've signed a judgment, so they now owe us that money. Any funds they raise will be used towards it. Whether or not they raise those funds or not is not something we can compel. But again, the judgment's in place, and any dollars they raise will be coming to the FPC or to the State General Fund.
Does this effectively end, like the SBAC, end their ability, if they collect money to spend it on other campaigns, say this year or in 2016, if you guys have first call, or the general fund has first call on any money they make?
Correct. For that particular committee, any funds they raise will be coming to the State General Fund until that debt is fully satisfied.
So they're precluded from spending it on anything else?
That's my interpretation, correct.
But to follow on that, Gary, couldn't, I mean, and I'm not saying they would, but couldn't the political backers of a committee like that simply form a different committee?
Correct.
And the debt only stays with the committee, not the people.
That's
so
absolutely
they could
correct.
just go do their business somewhere else.
That's correct. And I think that's one of the things we want to take a look at. Again, this was really a very unique, the first time we've pursued this type of case. It's certainly, by a magnitude of math I probably can't do, the biggest disgorgement in California history. I think the previous biggest one was $5,000. So as we now are being more aggressive in pursuing some of these cases, you know, it's given us a chance to both take a look at the front end of how do we make sure the disclosure happens, and then now we have a chance to look at the back end of, okay, what does that mean for the recipient, and how can we go forward in the future, and what changes, if any, need to be made.
So Gary, again, what was the total judgment? How much more would be owed after this point?
The total judgment against CFF, the California Future Fund, is $4,080,000. The total judgment against the Small Business Action Committee is $11 million, and then they made a $300,000 payment today.
So today, the only payment you've received outside of that $1 million fine is the $300,000?
That's correct.
The California Future Fund looked like it was established by a different entity, the American Future Fund. Wouldn't you be able to go to them?
The law does not allow us to pierce through that veil to get to them. There's no legal authority for that.
Therein lies another challenge to actually ultimately holding someone accountable for this.
Again, I think it raises important issues for these types of cases of who we want to hold responsible and how, and I think that's a good discussion to have, and I think we've brought a lot of that to light with this case. But I don't want to underplay the amount of money we recovered. $300,000 is a significant amount of money. As I mentioned, if it were considered to be a fine, it would be the second largest amount ever collected in California history, and I know it had an impact on the committee itself and the individuals associated with that committee. So I don't want to minimize that. I think that serves a significant deterrent effect as well.
So the legal entity is the committee that you would seek the money from, not the people who also sign the documents.
That's correct.
So that is the only entity really
Right.
that can pursue.
We, in our review, didn't see a clear legal path to getting towards the persons who were associated with the committee themselves. Although, truthfully, even if we had a clear legal path, because of the dollar amount of this, to the best of my knowledge, none of those people had $11 million lying around either, so I'm not so sure the result would have been different either way.
Aside from the two bills you mentioned, are there any lessons you learned this time around that would help you, arm you against potential for this happening this election or the next?
I think the second thing I said of the lessons learned is shouldn't be undervalued either, and that's that we shed a lot of light on how these nonprofit networks worked. I think we learned a lot about how money is moved around, about how donors are at least attempted to be not subject to disclosure, and we're going to take all those important lessons learned, plus our new legal authority and flexing our legal muscle, if you will, and applying that to this election year. But again, the goal of everything we do is to have people comply with the law. So the more actions like this we do, hopefully, or the fewer we'll have to do in the future, because people know that there's an entity out there that will take action against them if they engage in that activity.
Beyond the disgorgement that still remains, is there anything else that's still pending with
No.
these entities at all?
That concludes the matter from our perspective.
And the stipulation, I mean, it's that they're just stipulating that they owe the money, not that they broke the law, not that they did anything wrong.
For this particular issue, they didn't break the law. In fact, SBAC in particular was extremely cooperative with us in our investigation. But the point of this law is that you can have ill-begotten gains, if you will. If someone's not disclosing the true source of contribution, regardless of whether you knew that or not, you're not allowed to keep the contribution. I think the public policy behind that is, if you're inclined to hide your contributors, you should know that on the back end, they won't be allowed to keep that contribution in any case, or at least they'll suffer a consequence down the road for it.
In which case is there, I would assume then there's a message to political action committees.
I think this should send a very strong message to political action committees that, first of all, you need to have your due diligence done when accepting contributions. I do think they did their due diligence to the best of their ability here, but I think it's still a lesson learned. If you get an $11 million contribution from a group that you've never heard of, that's never contributed in California, that should set off some alarm bells that you may want to start asking questions, and hard questions. All right, thank you very much.
Thanks, sir.
Thanks, Gary.